Welcome, everyone, to another episode of our Intern podcast. Today, our guest in this episode is Samantha Bradley, who is one of our consultants at Ravenscroft Schmierer. Thank you so much for joining us, Samantha.
My pleasure.
Samantha, why don't you tell us a little bit more about your career path before joining Ravenscroft Schmierer? And specifically, can you tell us a little bit more about your role in a family office and what made you choose to work there?
I started practice back in the mid-1990s in London, and I worked with a large city firm where I stayed for many years until I left to join my first family office, where I had to set up an office for them in London, working in collaboration with an office that they had elsewhere in Europe. So when I went on board, what I discovered was it was a very wide and varied role. And for somebody early stage in my career with no other lawyers there, I found that to be something I didn't particularly find suitable for that point in my career. So I went back into the international law firm who needed some support on a sort of a major project involving a family office in Hong Kong. So I then got stuck into that for a number of years and found myself eventually running their new office in Hong Kong and then moving in-house into the family office of that particular client. I've always loved family office work because it's so varied, and because although I started life as a tax and trust lawyer, I ended up doing everything from commercial to disputes to regulatory to compliance, being a money laundering reporting officer. So you get such a broad spectrum of the law. You also, as a family office lawyer, get to work with many, many professionals. I happened to end up as head of legal of a large family office, one of the most mature ones in Hong Kong, with over 100 people working there. And I was supervising a large team on both the legal trust management side and also overseeing a whole group of accountants, overseeing the work and the quality or lack of that they did from time to time, and making sure basically that, that we had all that we needed. Normally in a law firm, you're much more siloed, and that certainly wasn't the case in a family office role.
So, given that your role is so varied, what would you say is your favorite part about your job, and what do you not enjoy as much?
I loved the varied role. I like to learn new areas. So for anyone who's a polymath, anyone who has a particular real passion for the law, that's a good pathway for them. But they do need to understand that, particularly with family offices, where you're very often going to be involved in the management of billions of dollars, you also have to actually be able to give advice, make decisions, and you have to be able to risk assess. So it's not a path for people who are extremely risk averse or frightened of giving opinions, which is one of the reasons why I tend to think it's a path for people later in their career rather than early. So consequently, it really isn't for everyone. I think the other thing, I also have a very deep value system. So for me, the most natural thing is looking after your clients. And a family office role is one where that really puts you in the forefront of it because you're in a direct relationship with your clients. That's one of the challenging issues about family offices, which is that they are full of conflicts of interest. But for somebody who genuinely has a vocation of caring about people and wanting to do your best, the closer you can get to the relationship of working for a client, the better. I think family office work is for, well, there's two types of people. There's those who have a vocation for really helping people. And then there's the other type of person who actually has the vocation for exploiting people because they're dealing directly with lay people without the proper regulatory system around them to protect those lay people that you get in a law firm.
With your experience in the legal industry, what do you think are the biggest challenges you've observed when it comes to access to justice within this profession? And as a family office lawyer, do you think your professional obligations can sometimes clash with personal obligations?
Absolutely. Because as a solicitor, your primary duty is to the courts and to the public interest, not to your client. But of course, the way that you have to navigate that is to do your best for your client and educating them as to what is lawful. Part of the rule of law is guiding our clients to keep them compliant within the rule of law. In my experience, the people that find themselves in the worst conflicts are because they've got bad clients who want to lie to judges, who want to mislead them, who want to bring false cases, are engaged in tax evasion, money laundering, all of these things. So there are certain things in life where the whole concept of commerciality conflicts inherently with what it is you're actually obliged to do, and we have to navigate that path.
So you talked earlier about trying to uphold the rule of law and dealing with bad clients. So what do you think are the biggest challenges you faced in terms of that?
Okay, so this is I mean, it's a matter of public record. I will pick my words carefully. I'm involved in cases in 2 jurisdictions where allegations have been put into court about the conduct of certain clients. Certainly over a career of 30 years, I've encountered situations where there have been concerns about clients, people have had to be, you have to stop acting for, and our duty is to the rule of law in those situations. Normally in a law firm, one is protected. Law firms have mandatory insurance. And that insurance is often said to protect the clients. The reality is clients can never access it unless they actually go through legal proceedings to sue. So it's also there to protect the solicitors. The Solicitors Regulation Authority have said that they will protect or should protect solicitors who have to comply with measures in order to report their clients or generally actually other solicitors who are acting in an improper manner, either as a client or for clients to enable them to undermine the rule of law. So working in a law firm, you get a certain amount of protection around these issues when you comply with your duties. Working family offices is the opposite. You're not within a regulated law firm. So if you encounter yourselves with bad clients and or working with bad solicitors, you're actually terribly exposed because normally in that situation, the insurer of the family office is on both sides of a dispute, and the insurer may find itself liable to protect people in the office as well as the individual who's trying to actually comply with their duties and the rule of law. As we all know, insurers generally can be very difficult and challenging to even pay up when they're supposed to. And the second challenge is that because they're unregulated, it's very difficult for regulators to actually go in and deal with problems related to the rule of law. So you can end up in situations where you find yourself in court having to justify your position as a solicitor, acting in accordance with the rule of law against people who may be frightful criminals, who may be negligent, or who may, just be completely misled. And so it's quite a challenging environment. And I think the duties on solicitors are not really well appreciated. In England, we have been going through a process involving what we call the Legal Services Board, which regulates the regulators, who've been demonstrating that there is widespread misconduct within the profession to address it on a self-regulated basis by even reporting it. And I've certainly found similar issues in Hong Kong. Complying with the rule of law is challenging because there are many commercial and personal pressures on people not to do so because you get retaliation. And it's far worse in a family office for people or any in-house counsel role where people go in-house. The commercial pressures to not comply with the rule of law, but to go along with whatever the prevailing culture is within an organisation, even if it's criminal, is quite serious.
To my knowledge, you will soon be involved in a court of final appeal case in Hong Kong, which relates to your past work. So would you mind sharing a quick rundown of the case for our listeners as an introduction to it?
I will restrict myself to what's in the public domain. So basically what happened in Hong Kong was I declared a repudiatory breach by my clients, my employer, of my employment contract. I entered into a settlement arrangement with them in circumstances where I had wanted a clean break, and they encouraged me to remain a consultant. And indeed, all the evidence demonstrates they asked me to continue to be a consultant and to do all of their work even after problems arose. I, again, concluded that they were in breach. And there is a lot of communication between us and where I alleged that I was being harassed and victimized as a result of concerns I would describe as fulfilling mandatory duties of reporting, which amounts to protected disclosures in the public interest. It's widely recognised and public knowledge that I alleged that there was an attempt to financially incentivise me not to comply with my reporting duties and to continue in a relationship with someone who I'd tried to leave various times because of the manner in which the individual behaved towards me and what they asked me to try to do, which I refused variously to do. Unfortunately, for various reasons I won't get into, I didn't issue proceedings first. I'm not litigious by nature. I prefer to try to deal with things amicably. I was encouraged to deal with things in a certain way, and they then preemptively struck. And indeed, the barrister on the other side has, in submissions to the court, acknowledged I may not have made a single wrongful allegation. And because I applied to have the case disposed of by way of a determination of law, for the purposes of that hearing, it was necessary that I not challenge the facts, and reserve the right to challenge the facts in a later hearing, which means that it wasn't possible for me to put my story into the public through the court system, which is how it's normally done. What I did do was put my story into the public domain through the employment tribunals in England, but we again had a hearing based on a preliminary issue, which meant that my full facts again didn't really get fully disgorged. Where we are now is that the case against me was dismissed in 2023 on the basis that there was no cause of action against me by the plaintiff, which was the family office in question. The action that was brought was an action alleging harassment by virtue of wrongful allegations, which normally would be curiously dealt with by a defamation claim, which they didn't make. In England, there is case law which indicates that it's likely to be an abusive process, where somebody brings a claim in harassment alleging wrongful allegations when they ought to have brought it in defamation, if that was truly the case. So this is a particularly problematic case, which we would call, I believe, in England, an economic crime slap, because it's basically designed to shut me up about allegations I'd made about economic crime. We tried to sort of kick it out without having to go through a very expensive and vexatious trial, and we were successful. But then what happened was that the lawyers in Hong Kong issued me with a notice of appeal, which they didn't serve correctly. They didn't attempt to personally serve me, nor did they attempt to comply with the Order 11 process, which applies to a foreigner abroad, despite the fact that they'd been notified that I was living abroad, had left and returned to my permanent home in England, and I certainly wasn't in the jurisdiction when they attempted to serve it. And there's no sign that we're aware of that they actually attempted to even use the Order 11 process. So I was misled and duped into believing that I had been served, when in fact I had not been. Once they did that, they then sought to amend later their case to introduce arguments by reference to what we call freestanding injunctions with no cause of action. In other words, if the first instance judge was correct that there was no basis in this case for the company to sue me, they tried to introduce a new argument in relation to the availability of freestanding injunctions. This was quite an interesting thing for them to do. Under the Order 11 process and in respect of foreigners, you can't actually get freestanding injunctions against foreigners who are abroad because you're not allowed to seek them under the Order 11 process. So then moving on from that, I decided to appeal. There's no common law jurisdiction in the world I'm aware of that allows companies to sue for alleged harassment. Indeed, Singapore and England have both legislated against companies suing this particular type of case. And I don't believe the common law supports it. So I've appealed because what they're really trying to do is to evolve the law, and that requires the Court of Final Appeal to make a decision on that. And interestingly, in this particular case, the Court of Appeal did not make any ruling on whether a company can sue for harassment. They merely sent the case back down to the Court of First Instance for what was going to be a very, very, very expensive trial based on the facts and a whole load of random communications that have been put in by the other side, who have made a big deal about the fact I sent over 500 emails. Well, I sent many more than 500, and they sent many hundreds of emails themselves, which they haven't mentioned. But they lifted large amounts of communications and just dropped it on the judge and said, let's go through everyone and see whether it's harassing or not. And these are communications where, for example, I'm being asked to do things I believe to be crimes and saying, well, I actually think that's a crime. Why are you asking me to do this? I don't believe it's in my contract. And so they've tried to argue that my refusal to agree with them on points constitutes harassment. Now, this is significant for two reasons. First of all, these are points of general public importance for all of Hong Kong. I'm not an isolated case, as every day writs are being issued. So the Court of Final Appeal is looking at these issues and trying to clarify the law. But what was of particular significance for me was that this late edition of this freestanding injunction, which hitherto nobody thought you could do in Hong Kong, there's a reasonable argument they can't, was used on appeal to send me back down for a very expensive and long trial, which I say is an abusive process and entirely improper. Now, I'm going to take a step back now and just speak as an English lawyer rather than a Hong Kong lawyer. Hong Kong perfectly is entitled to have its own culture, its own legal system, but the code of conduct rules in Hong Kong and England are pretty similar. The common law cases are pretty similar. And in England, we have a tradition now for some years of looking at these types of cases and finding that they are glorious abuses of process. I have a right to say, as an English solicitor with freedom of speech, that the government in England has declared that these types of cases are immoral. and some of them are criminal. This is basically a battle of free speech. This is also a battle of human rights and the right of the public not to be harassed by companies with vexatious actions. I'm hopeful that Hong Kong will, like Singapore and England, decide that these sorts of actions are completely inappropriate. But that's for them. I'm grateful for what they've done. I'm grateful for them adding this new ground appeal for me on freestanding injunctions. I'm grateful that they've decided that they'll look at the issue of harassment cases. I'm very grateful. From what I'm saying, I'm doing this as much in the public interest as I am for me.
Do you have any advice or any words of wisdom for this generation of young, aspiring lawyers in Hong Kong when it comes to helping safeguard the rule of law?
What I would say is that when I was your age and I was a younger lawyer, there wasn't really social media. In more recent years, more people have felt that they can speak up about these things. It's still very challenging for younger people. Everyone who knows anything about this case will know that I'm the subject of retaliation in circumstances where, if my allegations are correct, there are lawyers who are potentially negligent. So this is an area where when you speak up on anything that's particularly controversial, you are prone to retaliation. And as anyone knows from my LinkedIn, I'm not just dealing with this particular case, I'm dealing with other social interest issues. So for young people, there are some notable examples of very young people, and I'm thinking here of Rachel Cohen in America, who are speaking up. It is a dangerous thing for people to do because of the risk of retaliation. To be a really good solicitor, you have to have a strong mind. It's not a practice for people who don't have strong minds. I would encourage people to, early on in their life, really try to understand and sit and soul search their own values system and the rule of law, understand the rule of law, understand what it's about. Be aware of the fact that there is the duality that Joseph Campbell would describe as sort of the good and the evil on our shoulders. There is the demon and there is the angel, and they are both present in the legal profession. So young people need to understand that. They also have to protect themselves. And even the Solicitors Regulation Authority has recognised this and actually said that there may be exceptions where young people can't be expected to comply with the very onerous duties of reporting misconduct, discrimination, victimisation. And indeed, after my case, where I have suffered threats to my own personal security and had my dog stolen and other matters, they've actually issued guidance saying that solicitors shouldn't report if they think that it's going to result in their life being threatened. So young people need to understand this. When you join a firm, you don't know whether the firm is going to be an honourable firm. You don't know whether the partners you're going to be working with are honourable people or not. That's something you're going to have to work out. And the legal profession is one where people move around a lot. And young people can't afford the confrontations. But what you have to do is have a very, very strong sense of personal values and don't allow those to be compromised.
Thank you so much, Samantha, for what was an incredibly insightful chat. I really appreciate how you talk about learning to balance your personal values with your professional obligations and the importance of recognizing these values. For our listeners who are interested in learning more, I highly suggest you give Samantha a follow on LinkedIn, where she posts frequent updates. In the meantime, enjoy the episode, and thank you so much for listening.